1975, there were 8 million children who were not receiving an appropriate education. And 1 million of those children weren't receiving any education at all. Unbelievable. Of course, tonight, what we're going to be talking about is the laws and statutes of special education, children with disabilities, as we refer to those. We're going to be talking about the educational process, the special education process, from identifying students to implementing their program.
I noticed you had notes. I wasn't sure if you'll pass those out.
Yes, I was going to. And the third thing we're going to talk about is we're going to be talking about disciplining special education children. Of course, all three of these topics are extremely vital in the fact that in today's world, many of you have upwards to 25, 35% of your students are special education students. So we're talking about a good percentage of your students. What I decided to do is put this in critical events in special education. And the very first critical event actually was back in 1922. In 1922, the Exceptional Children's Council was concerned about exceptional children, children who were in closets, children whose parents were embarrassed and didn't bring them out in public. And in 1933, Cuyahoga Council for Retarded Children. Of course, that word today isn't politically correct. However, that's what they were called in 1933. And finally, the ARC, National Association for Retarded Citizens. And as time went on, there was concern about children with disabilities, special education children. And, back up for a second. I'm going to go to 1954. Who can tell me what the significance of Brown versus Topeka, Kansas Board of Education is? What's the significance of that?
Segregation of school children?
Yes.
Based on race?
In Plessy versus Ferguson in 1848, that was our standard up to 1954. Separate but equal was okay. Separate but equal was okay. In 1954, this verdict determined that separate but equal was not okay. And although it is the premier segregation case, it had bearing on special education because Chief Justice Earl Warren stated, in these days it is doubtful that any children may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, it is a right that must be available on equal terms. And of course, we've already established that 1 million children were not receiving those rights.
The gong sounded for the public address system, and the principal came on and said to us, Brown versus Board of Education has been decided, and in essence, the schools would be desegregated. My English teacher stood for a second with a tear in her eye, and she said, "Now I can retire in peace."
Oh, I remember it was headlines in the Afro-American newspaper back in Baltimore. It was good news. I do remember that it was an issue that was talked about from time to time in school by the teachers. And so it was something that we knew about, something that we knew was important, and something that was hailed as a great thing.
I read it in the newspapers. I was in my second year of law school at the University of Washington Law School. I don't remember my constitutional law professor even discussing it. So I did not learn about the Brown decision from law school. I learned it from popular reading.
I remember my family, my mother and my father, talking about something I now recognize as Brown. I can't say I remember it as Brown, but it was quite a topic to talk about around the dinner table.
Brown is probably the classic case, other than Roe v. Wade, of the court making a strong and clear decision, even in the contentious time, after Chief Justice Earl Warren was able to cobble together a unanimous decision. There were calls for impeachment. There were death threats. There was a Southern Manifesto where Southern congressmen said they would resist it by any means necessary. Governor Faulkner out Arkansas stood in the door, wouldn't let black children come into Central High School. Governor Wallace said segregation today, segregation tomorrow, segregation forever.
And you know, the impact of it isn't so much its impact on school desegregation, where I think it has been an overwhelming success, but more on how it spawned this whole movement to utilize the law for positive social change, and the way in which that sort of galvanized the civil rights movement and the women's rights movement and all of these other sort of major social change movements in the United States.
Which of course includes special education of children. Critical event 3, a couple of seminal cases. Park versus Pennsylvania. Who can tell me what the significance of this case was?
The significance of the case was that the court said that children with mental retardation were entitled to a free and public education.
Stop for a second. Free and public education. Never heard of before until this case. Go ahead.
And that whenever possible, they should be educated in regular classrooms rather than classrooms that were isolated from the normal school population.
Yes. And one other thing that came from the case was the term least restrictive environment. They should be educated in regular classes, those children with disabilities. The next case, Mills versus Washington, D.C. Go ahead, Jen.
It set the precedent that educational services must be based on a child's needs, not on the school's financial capabilities to provide the services.
Yes. And it also established adequate alternative educational services. And it established procedural due process. Now, those 4 items that were established in those 2 cases, what are those? What are those? Dick, what are those?
Not sure.
Not sure, okay. Special ed people, what are those?
Would you repeat the question, the question again?
Free public education, least restrictive environment, adequate alternative educational services and procedural due process. Jackie?
IDEA, the principles of
Yes.
IDEA.
It established the principles that we currently continue to use for a special education program. So you can see that it was just critical to do that. Event 4. Event 4 is 1973, Section 504 of the Rehabilitation Act. What's the significance of this piece of legislation on the federal level? Rehabilitation.
It was an act to protect individuals with disabilities from discrimination, to provide them with equal access to educational opportunities, facility utilization, and employment opportunities.
Yes. So the bottom line is, now the federal government is getting involved and passing legislation. And of course, then comes the Education for All Handicapped Children, 94-142, and of course all use special. How many people in here teach special education? Okay. Of course, you spent all kinds of time talking about 94-142. You probably have nightmares about it, don't you? Go ahead. What's the significance of this particular piece of legislation?
That the federal government was going to intervene and make sure that the schools were providing the necessary education for children with disabilities.
Absolutely. That is the first time the federal government said we are going to educate children with disabilities.
There were 2 laws that were enacted. In 1973, Section 504 of the Vocational Rehabilitation Act was enacted. And that was the civil rights movement sort of began to embrace the notion of people with disabilities. So that law was passed, and what it did was, it's a federal law that said that you can't discriminate against people who have a severe limitation on one or more major life activities. And the major life activity that we're concerned with in school is learning. So if people have a disability like that, an impairment, then if you take federal money, that what you have to do is be willing to accommodate, to make a reasonable accommodation for these kids to be in school. A really good way to think about Section 504 is a wheelchair ramp. So if you are able-minded, but maybe not able-bodied, and if somebody can get you into a building, and then you can do your job, or you can be a student and you can learn, then building a wheelchair ramp is that accommodation. That sort of levels the playing field for you. A lot of kids who have attention deficit disorder, a reasonable accommodation is some sort of a cubby, something around them. So for those kids who pay attention to everything, hopefully that reasonable accommodation will make it so the child can pay attention to the work in front of them. So we weren't yet at the point of talking about educating people with disabilities, children with disabilities, but we were talking about making it illegal to discriminate against them. So the education piece came in. Prior to 1975, if you could walk and talk and hear and see and had the capacity to learn, to read and write and do math, you were welcome in public schools. But if you couldn't, then you weren't welcome. And parents either kept their children at home or they institutionalized them. And the same civil rights movement, they became aware of the need for the education of these children. So a lot of civil rights groups and a lot of parents filed suits, especially one in Pennsylvania, that said, okay, public school, I pay my taxes, why can't my kids go to school? And the Congress responded by enacting the Public Law 94-142, which is the Education of All Handicapped Children Act. So it's morphed into the Individuals with Disabilities Education Act, IDEA. But over the years, a lot has changed, not just the name. What I told you was this was a law that was enacted to bring more kids into schools. These kids with disabilities that hadn't been allowed in school before. But what happened is very interesting because Congress, when they passed the law, said, okay, states, okay, districts, here's what you need to do. You have to go off and you have to hire all these teachers, hire the evaluators, get the professional development, make space in all your schools. That's your job because these kids are coming. And then Congress said, and here's the commitment that we will make. We will fully fund within 5 years this program. And by fully funding, what they meant was, we will provide 40% of the national per pupil expenditure times the number of kids with disabilities, and we'll give you that much money over and above what you typically get. So you can see initially there was some incentive to identify children because your money that you received from the state was based on their head count. That's changed, but for the first 15 years, that was the way the money was allocated. The challenge is that 10 years after the law was enacted, the level of funding had increased to like 7.5%. Understand it was supposed to be 40. And so it increased to that much, and now it's up to maybe 18%, but it's never been fully funded. So what you have, which is words administrators hate to hear, is an unfunded mandate.
So, not only with these pieces of legislation, there are strings that are attached. And of course, as we had talked about with regard to the federal role, the federal government doesn't want to get involved in education. However, the way they get involved with education is offer programs and attach money to those programs. And if you decide to select those, to receive those monies, then of course you must provide the program the way they lay it out. Okay? And the way they laid it out was these